Hello, everyone, and welcome to Uncivil Law. Today's case deals with a person taking photographs of women at Walmarts and other locations in potentially creepy fashion, but the question is whether it was an illegal fashion, whether this person was engaging in violation of privacy or otherwise. So today's case is from the Court of Appeals for Tennessee. This is the state of Tennessee versus David Eric Lampert. In this case, Mr. Lampert was taking photographs. Some women felt that that was improper. He was reported and he was convicted. And the Court of Appeals was trying to determine whether or not the conviction was proper for these photographs. So let's read a little bit about the facts. Let's read a little bit about the law and figure out when being a creepy photographer might cross into illegal conduct. Let's get started with this. The Sullivan County Grand Jury charged the defendant via presentment with one count of unlawful photography for conduct at a Walmart in Kingsport on February the 27th, 2016. Prior to trial, the defendant moved the trial court to dismiss the charge against him, arguing that because his alleged actions occurred in public places where there's no expectation of privacy, they are not illegal under law. So he's got the right idea. Whether or not there's a reasonable expectation of privacy is going to be one of the major things that's going to trigger this. If there's no reasonable expectation of privacy, pretty much anyone can take a photograph of anyone else. This is exactly how the paparazzi operate. They can generally be in a public place and generally take photographs, of people who are in public. There's no expectation of privacy. So if you want to go around taking photographs of people, you can do that as long as there's no expectation of privacy. So he's got the right idea. The Kingsport police detectives, Martin Taylor, testified that following the incident at a Hobby Lobby in Kingsport, he interviewed the defendant on March 24th, 2016. So this is not his first rodeo in this issue. So this guy has been interviewed by the police before, where this particular case deals with the conviction at a Walmart. But let's talk a little bit about this prior interview that occurred at a Hobby Lobby. So here's what happened in that case. At the conclusion of that interview, the defendant provided a statement that Detective Taylor read into the record. Okay, so the defendant, during a prior investigation at a Hobby Lobby, provided a statement to the police. His statement is now being used against him, which, again, reminder, don't talk to the police because we run into these problems. But here is what the officer says he said. Statement against interests are not hearsay, right? So the defendant apparently says, "This all started 4 or 5 years ago when my father died of cancer. I began videoing in public. I like blonde-haired females, but I have no preference really. I recently have been going to shopping center in Kingsport and been filming women in Hobby Lobby, Walmart, and Ross, and the shopping center on East Stone Drive. I did not mean to scare anyone. I only film females for my own purposes. Super. I just like using the video function on my phone. It's kind of an obsession I have with the technological aspect of the phone. I've never posted any of the images I've taken on the internet or shared them with other people. I actually did not think I was doing anything wrong because everything I did was in a public place. However, I realized there's no good decision on my part. It was not illegal. It was crossing moral boundaries." Well, whether or not it crosses moral boundaries or not is not a legal issue, so I'll leave that for someone else to decide whether or not it poses a moral problem. The defendant continues. "I gave the officers permission to look through my phone. Today, I'm giving Detective Taylor permission to examine my phone for videos I've stored on the phone. There should be around 20 videos of the phone of different females I've collected recently." He's a collector. He's got 20 videos on his phone from women he's collected in the Kingsport area. That's fun. "I understand the seriousness of the charges against me, and I need help with the problems I have." Well, as to that aspect, you may well be right. You may need help. You may, in fact, need help. But whether or not you are criminally liable is the issue we're trying to resolve right now, whether or not you're a criminal suspect or not. You may, in fact, need help, yes. "I'm willing to undergo treatment with the willingness, and with the willingness of the court will do whatever is necessary to get help for my problem." You should do that, probably. It sounds like a good idea. "Again, I'm very sorry for this. I want women to know I videoed. I never meant any harm, and I apologize. This is a truthful statement." Okay, so we have this prior statement that he gave during a prior interview at a prior incident at a Hobby Lobby. He's videoing women at a Hobby Lobby. Okay, great. And he had 20 women on his phone at that time, and he goes around and collects them for his own purposes. Encouraging. And he's saying that, he realizes there might be moral issues. Well, moral issues are for someone else to figure out. We're here to figure out the law. Is he violating the law by collecting any of these photographs or videos? Or more importantly, to our immediate purposes, was he violating the law and collecting whatever photographs or videos he was at this particular Walmart because that's the criminal conviction we're interested in. So was that a crime or not? And this statement was read into the record as part of the trial. So there we go. Detective Tyler stated that he examined the photographs and videos, but he found no photographs or videos of any of the victims in 3 cases. So whatever victims he was looking for were not one of the videos that he found. Okay, so now we get to the incident in question. What actually happened here? Shauna Sutton testified that she was shopping at Walmart in Kingsport on February 27, 2016, when she encountered the defendant standing by the door. She said the defendant appeared to be approaching her and that the look he was giving her made her uncomfortable. So she chose to go out the doors and around the outside of the store to get to her car. When she looked back, she saw the defendant was walking in the same direction and matching my pace, which, would freak me out a little bit too. Whether it's legal or not, again, but it would definitely freak me out. If someone was following me in my car, that would freak me out a little bit, yes. When she looked back, she saw the defendant was matching the same pace. She said at that point, she let the defendant go in front of her and then veered off to the left, going in between the car, hoping to lose him. She said the defendant was at an arm's length of that close and had a cellular phone down and out towards the lower half of her body and appeared to be taking photographs or video of her. So that's super duper encouraging. This guy was following her to her car, apparently at the same pace as her, so following at the same distance from her, and photographing and videoing. Now again, putting aside the legal issues, I can understand being creeped out by that. If someone were doing it to me, I'd be creeped out by that, because it's not what normally happens. Normally in our everyday lives, we are not normally followed by paparazzi. So this may be something that someone who's in the press or someone who's a public figure might be used to. But it's not something that we're used to. So if it happened to one of us, we'd be freaked out about it. But the law is the interesting thing, because again, if a paparazzi can do it to a public person, can any individual do it to any individual? Because we do work under a system where we have equal justice under law, right? So a paparazzi is a private figure. A public figure is private for the purposes of most law, right? They're a private person. They're not a governmental actor. So you have a private person following a private person. Should it matter if it's paparazzi, famous person, or random individual, legally? So that's the question we're trying to do. And if this is illegal, why is the paparazzi doing not illegal? And if the paparazzi, what they're doing is legal, why is this not legal? So that's the issue we're trying to resolve. We're trying to apply this equally to everyone. And what he was doing was concerning, disturbing, but was it illegal? Let's press on. During cross-examination, Ms. Sutton testified that she was clothed in black pants and a gray short-sleeve t-shirt with a black long t-shirt underneath it. She said the defendant not attempt to photograph her down her shirt or pants. So that would be obviously an invasion of privacy. So we've definitely seen photographs with people trying to take, up from behind or down from below, right? So we've definitely seen those kind of photographs, or taking photographs in changing rooms, those kind of things, right? So that would present a different problem. If you were doing that kind of thing, that would present an issue of privacy. But this defendant wasn't trying to do that. He wasn't trying to get up under you and take a photo from underneath, or trying to take a photo from on top. He was at a distance, taking photographs from a distance. So he wasn't doing those kinds of things. He's doing different things. She said that the defendant stopped when she told him to do so. So when she said stop, he stopped. Okay. I'm not sure that he was legally required to, but he did. She acknowledged that she assumed she's being filmed by surveillance cameras both inside and outside Walmart, and agreed that had the defendant photographed her, it would display the same image captured by surveillance video. She admitted she did not know where the defendant had actually taken video or photos. So that's really important, again, going to the expectation of privacy and stuff like that. Can she be videoed? Can she be photographed? Well, Walmart or Ross or Hobby Lobby, again, are private actors. They're not the government. So we're looking at the private person kind of contact, right? And what a private person can do to a private person. Can a paparazzi take a photograph of a famous person? Can a business take a photograph of people in their store? Can a random individual take a photograph of another random individual? And legally, they're all in the same position, right? And so she says, well, yes, I assumed I was under surveillance in Walmart, as you would. I mean, it's not conceding anything that isn't obvious. And had she not conceded, you get someone else to be there. So, of course, there's surveillance in Walmart for shoplifting. Of course there is. So She is being photographed, videoed, and perhaps under audio as she's in the store by Walmart. Walmart is doing it, probably in their parking lot too, I would imagine. So she's under this video, photograph, audio surveillance by Walmart, and she acknowledges that she's aware of that. So how can she have an expectation of privacy is the operative issue, as it applies to this guy. If she doesn't have an expectation of privacy from Walmart, she doesn't have an expectation of privacy from this guy, because Walmart is in no better position than any random person. Now, they're in a marginally better position because it's in their property. So obviously they can install cameras in their ceiling and on their property, so they can install cameras where someone else wouldn't be able to be. But as the actual taking of it, they're in no better position. So if he can't do it, Walmart can't do it, the paparazzi can't do it. If we're going to look at everyone equally, we have to look to their conduct objectively. And what was he doing? He was taking photographs from a distance. So it's exactly the same thing Walmart is doing. If he's guilty, Walmart's guilty. So yeah. As to this case, trial court found the defendant had readily admitted to videoing or filming or taking pictures with his phone of women in public. So he admits that he does this. He takes videos and photographs of women in public. Creepy, but not illegal. The court noted that Mr. Sutton, or Miss Sutton, believed that he was taking video of her, and the surveillance video showed the defendant walking beside a little bit in front of Miss Sutton with the camera down in front of him near her, and as soon as he crossed by, the very first thing he did, he looked at his phone and what he captured. So that's pretty creepy. He has his phone down near him, but it's not, it's a little bit creepy. Oof. The court found Miss Sutton had a reasonable expectation of privacy given the proximity from the capturing. So the trial court at least is trying to distinguish this on proximity grounds. It's saying because you were so close, that's what gives you an expectation of privacy. Okay, that's what the trial court was trying to do. In consequence of this, the court ruled on the defendant's guilt was a jury question rather than a question of law and denied motion to dismiss. So they went to trial over that. Okay. So now we must turn to the code in question and analyze what it says exactly and whether it applies to this conduct, and also whether it's constitutional for that matter. So we have to look to the actual statute and what it does or does not provide. So let's look to that and see what it does. All right. At the time of the offense, the case in this question, the code provides as follows. It is an offense for a person to knowingly photograph or cause to be photographed an individual when the individual has a reasonable expectation of privacy. So that's a pretty important caveat right there at the top. When the individual has a reasonable expectation of privacy. Important caveat. Without prior effective consent of the individual. So sometimes you'll see like signs that say you're being photographed or whatever. That might be consent, okay? Or in the case of minor, without prior effective consent of the minor or guardian, okay? So you have to have an expectation of privacy, and it has to be done without consent, without prior consent. So if you have an expectation of privacy, you need consent. If you don't have an expectation of privacy, you don't need these things. So this expectation of privacy is a predicate in the preamble. It's going to influence all these things, okay? So let's read on. If the photograph would, if it would offend or embarrass an ordinary person, if such a person appeared in a photograph, okay? If it was taken for the purpose of arousal or gratification of the defendant. There we're thinking about skirt pics or upskirt pics, right? Specifically, probably. And as used in this section, unless context otherwise requires, photograph means any photograph or photographic reproduction, or still or moving or videotape or live transmission of any individual. So yes, photograph means all these things. All photographs taken in violation shall be confiscated and used after evidence destroyed because they were taken unlawfully. Fine. But we can see right away the problem is the predicate, right? That predicate about it has to be done with the expectation of privacy. So even if you have a purpose in mind of gratification, if that's your purpose, if you're taking the photograph in a way that doesn't create a problem with the expectation of privacy, the statute does not apply. So you need that predicate, and that's a problem here. As indicated, the defendant challenged the constitutionality of the section on the grounds the phrase, when an individual has a reasonable expectation of privacy, is vague. Essentially asserting a claim fails due to vagueness. So the first thing that this defendant is going to try is saying, well, the statute is unconstitutionally vague. It doesn't put me on clear enough notice about what is protected and what is not protected. So it's vague, and therefore I can't be held liable because it doesn't define what expectation of privacy is. What about that? The defendant correctly points out the phrase that when a person has a reasonable expectation of privacy is not defined. It is, however, a phrase commonly used in law. It's a well-worn phrase, yes. The discussion of existence of a reasonable expectation of privacy most often occurs in cases discussing the Fourth Amendment to the United States Constitution. When the police can and cannot conduct searches. Expectation of privacy is pretty important to that too. But it's not limited in that arena, and we can fathom no reason to ascribe the phrase in this section to a different that than it enjoys in every other legal context. It's a well-worn phrase. It's well understood in Fourth Amendment law, not exclusively that, but it comes up quite a lot. And, if you don't have an expectation of privacy, the police, what they can do and can't do is different. So we're going to give it the standard meaning that's given everywhere. It's well established a person has reasonable expectation of privacy when a person has an actual subjective expectation of privacy and a person is willing to view that as reasonable under the circumstances. So you have an expectation of privacy if you want to be private and society would grant it. So in your home, in your car, in a changing room, yes, but where do people treat spaces as private? In bathrooms, those are spaces that people treat as private. In a Walmart parking lot, no, not so much. That's not private. It's in the open. Everyone can see everything. There is no expectation of privacy. So it's not a problem. Utilizing the common understanding of the terms contained in the code section, we conclude that does not prohibit conduct in terms so vague that a person must necessarily guess at its meaning. Consequently, the trial court did not err by denying the constitutional challenge. Yeah, no problem on the constitutional grounds. This is a well-worn phrase. Reasonable expectation of privacy is not unduly vague. You know what they're talking about. The spaces that people want to be private and where they're not. You just look how people behave and how they act. People behave in certain ways in certain spaces and others in other spaces. And so it's like you need to have the subjective expectation of privacy. If you don't care about your own privacy, society isn't going to care. So if you don't subjectively have an expectation of privacy, then no one cares. So if you subjectively don't care, then sure, people can take photographs inside your home or wherever because you don't care. So society's not going to protect you either. If you don't care, that's cool. We're not going to care for you. So if you don't have a subjective expectation of privacy, no problem. But even if you do, it needs to be one that society recognizes. And there are certain spaces society recognizes and certain it doesn't. In the middle of Walmart is not one of those spaces. If you're in the changing room of Walmart, the bathroom of Walmart, yes. But in the middle of the open floor of Walmart, in the parking lot, no. Anyone can see you, observe you. No expectation of privacy in these spaces. The defendant contends the trial court erred by admitting his statement into evidence, arguing the admission violated the rule of evidence on propensity evidence. So his next challenge is that you violated my rights by bringing in that prior statement that I gave to that detective from Hobby Lobby. That's a prior incident. You're bringing in that statement. Now, it's an admission, but isn't it an admission to a crime? Is it an admission to something that's unlawful? If it's an admission to a crime, it can be brought in. A generalized admission is not admissible. So if you're just admitting to things that are legal, they can't be brought in because it's improper propensity evidence. You want to convict people because of what they're doing, not because they've done things in the past. So you can only bring certain things in under certain conditions. So he's saying, well, look, this prior statement shouldn't have been brought in. It violated my rights to bring it in. So is he right? Is this prior statement that we read from before should have been brought in? We begin by noting that the defendant's statement that we read above does not contain any admission to wrongdoing specific to this case, which it doesn't, nor could it because it was captured at a different time. So, but if it had, right, if it had been a statement relevant to this case, that'd be different. But it's not. So it doesn't have any relevance to this case and such, okay? He's not asked about any incident that precipitated the charge in this case, okay? As a result, he made no admission of guilt directly related to this case. Yeah. Instead, his statement contains a general admission that he'd been using a cellular phone to videotape women in the area. The admission of evidence of other bad acts by a defendant is governed by Tennessee rules of evidence. Generally speaking, evidence of a person's character or trait of character is not admissible for the purpose of proving action in conformity therewith on a prior occasion. So yeah, you can't bring in character evidence in general to show propensity. You have to show something more. And here the question is, well, did the government show the thing more they need? Little Pink Bowser says they can use the statement as something to do with the current case. No, it doesn't. How could it possibly have something to do with the current case? That statement was captured on a prior incident, on a prior time, at a prior location. It happened before any of these things. That statement was taken in response to an incident at a Hobby Lobby, but prior to this. So how could it possibly have anything to do with this current case on its own face? It doesn't. It can't possibly. He can't be admitting to anything that happened in this case because it hasn't happened yet. He can't be admitting to like photographs or nothing's happened yet. It can't possibly have any direct relevance. So maybe it has some indirect relevance, but it can't possibly on its own terms relate to the case. So that doesn't quite make sense. The rationale underlying this general rule is an admission of such evidence carries with it inherent risk of a jury convicting a defendant of a crime based on bad character or propensity rather than the strength of the evidence. Yeah, we want to convict someone because they did this particular crime, not because they've done crimes in general. So just because you have 20 times speeded before, it doesn't necessarily you were speeding on this particular occasion. That's propensity. So we can't bring in evidence that shows, well, you do this in general to show the specific. $5 from Funky Fudge 11. Do eavesdropping statutes collide with having an expectation of privacy? Most eavesdropping statutes I've read require an expectation of privacy. So the statutes I'm aware of require an expectation of privacy. Now I'm struggling because I'm trying to remember like Massachusetts and Illinois and how their statutes are written, because they may prohibit like audio recording even in other situations, but I don't know the laws in those states specifically enough. But wiretapping statutes or eavesdropping statutes generally require an expectation of privacy. So I don't think there's a clash there. Recording video with audio be any different? No, presumably no. Again, I'd have to double check my law to be precise, because sometimes some states have treated audio differently than video in wiretapping and eavesdropping statutes with recording of audio. But to the best of my knowledge, most of them still have the touchstone of expectation of privacy. So you should be able to record video with audio as well without it triggering a problem. But I'd have to get into the specifics. I think Massachusetts and Illinois law might be written a little bit differently, so that's why I'm a little bit hesitant. And it's also not clear to my mind that those statutes are constitutional because of the First Amendment concerns. It's not clear that it's constitutional for any state to ban someone from recording audio if there's no expectation of privacy. So, I mean, yeah. Tennessee recognizes 3 instances in which evidence of uncharged crimes may be admissible: to prove identity, such as motive and common scheme or plan; to prove intent; and to rebut a claim of mistake or accident if it's asserted as a defense. As was the case in McCary, none of those exceptions are present here. The defendant's identity isn't an issue because he's captured on the video and conclusively identified. So we don't need to bring in the statement to prove identity because we already know who he is. Additionally, the defendant did not assert that he was not the man in the video, but simply characterized his contact as non-criminal. So he wasn't saying, well, it wasn't me. So we bring in a statement, oh, yes, it was you. No, he didn't say it wasn't him. He simply said it wasn't a crime. But he admitted to doing it, so we're not using it to identify. Similarly, the statement was not admissible to prove motive because he did not make an issue of motive. So yeah, we don't need it to prove motive. He's said what my motive is, so it doesn't work. Finally, the defendant did not assert either accident or mistake of fact as a defense to a charged offense. So admission of a statement was not necessary to rebut. So he wasn't saying, oh, I only did it as an accident, or I thought one thing when it wasn't another. He wasn't arguing that the statement was being used to rebut it. No, he wasn't making those defenses. So consequently, the statement, which did not include any admission directly related to this case, is not admissible on any issue material and should have been excluded. Yeah, Michigan records audio for a third party, even if it's public. That's interesting. The Project Veritas video was arguably taken in a place where there was an expectation of privacy, because expectation of privacy again is pretty context dependent. So even in a public place, you can have a limited expectation of privacy. So if because those videos, for example, as I remember, apologize. Those videos in the Project Veritas cases, I remember, were taken where they were like sitting at a common dining table in a restaurant. Now, in one sense, that's a public space. But in another sense, it's also a very intimate public space. So there is an expectation of privacy there. So I think you can make an effective case of reasonable expectation of privacy. Now, again, if someone happens to be photographing from across the room, that's different. But having that audio recorder like on your table, that would be a violation of expectation of privacy, because people are not expecting people to hear like that well. Like if someone happened to be like videoing and capture the audio, there'd be a difference there because there's no expectation of privacy. But the idea of having that recorder right there does violate the expectation of privacy, even if it's in a private place. So you can have an expectation of privacy in a public places where the circumstances demonstrate that expectation. So if you were in a place where you're in a common table and speaking relatively small, that might be something where you have expectation of privacy. But again, there's nothing like the facts here. So expectation of privacy can be fact specific, but I don't think the Project Veritas case contradicts this, because those situations were captured in what arguably was an expectation of privacy because of the nature of how they were done. So a little bit different factual pattern there. And I'd be a little surprised if Michigan state law really just blatantly says no recording if you're a third party. Again, that seems like it can't be right, because again, if you happen to be taking a video and people are having a conversation as they walk by, if you happen to be in a public street and taking a video of whatever, and people are walking by having a conversation, it can't be that is a violation of Michigan law. So it can't be that Michigan prohibits a third party from recording audio to a conversation. It probably has to have some sort of invasion of privacy element. So I think the statute probably is a little bit more specific than that, if I had to guess. When examining the sufficiency of evidence, this court should neither reweigh evidence nor substitute its inferences for those drawn by the trier of fact. Examined in the light most favorable to the state, the evidence established that the defendant followed Miss Sutton both inside and outside Walmart in Kingsport, and that he extended his cellular telephone towards her in a manner that led her to believe that he's being photographed or videoed. At all times during the encounter, Miss Sutton was fully clothed and in a public place, not in a changing room, not in a bathroom, something like that. No photograph or video recording was ever discovered in the defendant's possession or disseminated in any way. In consequence, the state presented no photograph or video recording for the jury's consideration. So if there had been actual videos or photographs, those might have been admitted to show that maybe there was an expectation of privacy because of the way the photographs were taken. So that wasn't available. In our view, therefore, the evidence was insufficient to establish all the elements of the offense. The code section makes it illegal to photograph an individual without consent when they have an expectation of privacy. As discussed above, a person has an expectation of privacy when they have an actual belief as to privacy and whether society is willing to subjectively grant it. As the Supreme Court has explained, what a person knowingly exposes to the public, even in his own home or office, is not covered by a reasonable expectation of privacy. But where they seek to preserve as private, even in an area accessible to the public, may be covered by a reasonable expectation of privacy. So this is, again, going to that Project Veritas thing. Again, going to that Project Veritas thing and the differences therein. Because if you are exposing it to the public, if it's in your home or business, we don't care, because you're exposing it to the public. So, and by the same token, just because you're in a public place doesn't necessarily mean you don't have an expectation of privacy. So the Project Veritas stuff doesn't contradict this, to the best of my belief, because that stuff was recorded in a setting where, even though it was in a public place, it was done in such a way as to create an expectation of privacy, a reasonable one. They were talking across the table, in an intimate setting. There's an expectation of privacy. So that is factually distinct from this situation. So yes, you can have a reasonable expectation in public. It's not as simple as saying you're in public, therefore you don't have an expectation of privacy. If two people are having a conversation on a park bench and you use a shotgun mic to record their conversation, that's going to be a violation. Even if you were standing right next to them, you could hear it and record it, because the expectation of privacy is such that applies. So you have to look to the whole context. Miss Sutton testified that she did not expect to be photographed by the defendant, but she did not testify that she expected her person and her outside clothing to remain completely private. Indeed, she acknowledged that she has full view of any person in the store or parking lot. Moreover, the evidence established that any image the defendant might have captured was also captured by a Walmart surveillance video, so he was in no better position to capture anything compared to Walmart. So his photographs, had they existed, would be just the same as Walmart's. No evidence suggests that the defendant attempted to photograph Miss Sutton underneath her clothing or once she was inside the automobile, where she would have an expectation of privacy. Consequently, we conclude Miss Sutton did not have a subjective expectation of privacy. Moreover, even if Miss Sutton had supported the conclusion that she had a subjective view, that subjective expectation is not one that society would view as reasonable. Exposure of capture to her images by camera has become, perhaps unfortunately, a reality of daily life. And we're all being captured on camera all the time. When nearly every person goes through about their day with a handheld device capable of taking hundreds of photographs and videos, and every public place is equipped with a wide variety of surveillance, it's simply not reasonable to expect our fully clothed images will remain fully private. Yeah. Anyone can be taking photographs and videos at any time in a public place. And, without more, it's not an expectation of privacy. In order to arrive at the conclusion that the defendant was guilty, the jury had to conclude that Miss Sutton had a reasonable expectation of privacy in the parking lot of the Walmart. Defendant had actually taken a photograph or video of her, despite the state having presented no proof that either existed, so that's a problem, and that this absent image would have offended or embarrassed the person. So, yeah, that the photograph did exist and it would have embarrassed, yeah? Although the state is entitled to all reasonable inferences from proof, the jury may not speculate an accused into the penitentiary. Yeah, that's a little bit much. We can sympathize with the plight of the state, but a conviction for a criminal offense cannot be predicated solely upon conjecture, guess, speculation, or mere possibility that a person may be guilty. In this case, the series of inferential leaps necessary to support the conviction crosses the line from reasonable to speculative, particularly in light of the absence of any photograph or video recording. Accordingly, we hold the evidence was insufficient to support the conviction of unlawful photography. The defendant's conviction is reversed and the charge is dismissed. So that is the end of the criminal case of the state of Tennessee versus David Eric Lampert. In this case, we learned that Mr. Lampert likes to go around taking photos and videos of people at locations and has done so many, many times and has been called out by the police many times. And the women find him creepy, which is completely unsurprising. But as to the law, as to the photographs themselves, and I say that with deliberation, as to the photographs themselves, they are not unlawful. Now, whether or not he was guilty of something else by, following this woman to her car or whatever, whole different conversation. Presumably, no, he wasn't, because he wasn't attempting to overtake her or anything like that, following at a distance. Again, the example to the paparazzi is the material one. Can the paparazzi do it to a famous person? Can a store do it to a customer? Can an individual do it to an individual? We're looking in private to private contact. And we're looking to whether or not this is the kind of contact that's illegal. So, was the photograph illegal? No. He was taking them in a public place. He's taking them from a distance. He wasn't up close. He wasn't trying to get up under or over top. He wasn't taking anything in a private setting or where there's a reasonable expectation of privacy. The record seems to clearly reflect this woman was just walking around the store and he was walking around too and taking photographs and videos, which is super, super creepy. And I wouldn't object to her going to Walmart and saying it's super creepy. And I wouldn't object to Walmart excluding him from their property, as they have a right to do as private property owners. So if Walmart wants to ban him, or if Ross or Hobby Lobby or anyone else wants to ban them from his property for that'd be perfectly fine. They're private actors and they can do what they want to do. So if they want to ban them, that's cool. And I don't object to these women being creeped out by it and fearing for their safety. Someone did to me, I'd fear for my safety too. But on the letter of the law, there's nothing here that's illegal, because again, there's nothing here a paparazzi can't do. And unless we're willing to ban it for the paparazzi, we can't ban it here because we have equal protection of the law. So even though it's not something a normal person would expect, there's nothing here that makes it criminal. So not an unexpected verdict, not a surprising verdict, perhaps one that's a little controversial because of the specific nature of it. But when you apply the broad principles that we generally live by, it seems like the only potential conclusion. And I hope that, notwithstanding the fact that he's been now acquitted because the charge has been dismissed, so having that case struck off the books, I personally hope that he will get the help that he alluded to earlier. He seems like a person who could use some mental health treatment. He seems like he has some issues that could use some counsel. So I suggest that he may wish to do so, notwithstanding this. And perhaps he can become a less creepy, less challenging member of society. But for the meantime, that's the end of our current coverage of this case.